So this is going to cover what happens to your estate if a child dies before you do. So we get the question quite a bit as people are arranging their legal affairs. Paul, what if my child happens to die before me, or if my child predeceases me, what would happen to my estate? So there's several different components to that question and answer. So I'll go through 3 or 4 components. The first one is if somebody dies and their child has predeceased them. The first component is if the person who died had no legal planning in place. They died intestate. Then the state of Louisiana controls who gets that person's estate. And let's say dad died, he had no planning, and he had a daughter, but the daughter died before dad, and the daughter left 3 children, 3 grandchildren of dad. Well, if dad has no planning in place, then when dad dies, the part that would have gone to his daughter would go to his daughter's 3 children. So the 3 grandchildren represent the daughter. So that, again, that's the case if dad dies intestate or has no planning in place. Now, let's say dad does get some planning in place. He has wills, maybe he has a trust, has beneficiary designations on his retirement accounts and his life insurance. Well, now all of that documentation controls what happens to dad's things when dad dies. And doing this for so long, I know that in most estate planning documents, the kind of typical default provision, it's typically expressly stated in the will or the trust, if a child predeceases me, then the child's share will go to the child's children. So that's kind of typical, but people can do whatever they want to do. Some parents, grandparents are very adamant. They want to say if a child dies, they don't want anything going to the child's spouse or the child's stepchildren, or who knows, there could be any number of circumstances. So that kind of stuff needs to be thought out, and some of these what ifs need to be addressed in the estate planning discussion and in the estate planning documents. So when you're getting your things in order, if it's important to you, or if you've had that unfortunate circumstance apply where a child has predeceased, then you need to go ahead and address that the right way. Some people try to address things that they can't address. So, for example, sometimes dad might say, well, I want my daughter to get her share and when I die, and then when she later dies, I want what she got from me to go to, so-and-so, my grandchildren or whoever. Well, once you leave an inheritance to somebody, if you leave it to them in their own name, you leave assets to your daughter, it's theirs. You don't get to control what happens to it after they inherit it in their name. So then it's going to be up to your daughter to provide, where that part goes when she dies. Now, yes, you can use certain trusts and say, I leave, a certain assets in a certain way to my daughter in trust, but then when she dies, it goes on to so-and-so. But generally, once you leave an inheritance to someone, you lose control over where it goes after that. So those are the 3 scenarios. If you have no planning in place, the state's going to control what happens if a child predeceases. Typically, the child's share would go to the child's children. 2, if you have some planning in place, the written document controls. Most written documents have some kind of a default. If my child dies before me, the child's share goes to my child's children. And then just know that you're limited on what you can control if your child dies after inheriting from you. Then really your child controls what happens to the inheritance after that. So that's some basics on what happens if my child dies, but conversations that are important and we have as we sort through this with people. Hope this helps. Go take care of business.